Hi everyone, welcome to Tiger Private. I'm Laura Glendenning, the head of Tiger Private, and I'm here today with Sofia Syed from Keystone Law. We're having a Q&A session today all around domestic employment and contracts, focusing specifically on contracts and some of the questions that you've emailed in around that. We're also having people watch live, which is exciting and terrifying at the same time, who will be able to get in touch live and ask any questions. If we're not able to respond to those during the Q&A, we will make a note of any questions that you have and get back to you after the session just to cover anything that you may have asked us. So welcome, Sophia. Thank you for coming in today. I'm going to start with the first question that we had emailed through from quite a number of candidates, actually. And it's just about contracts, and is it important and essential to have a domestic employment contract in place?
Sure. Well, yes. The important thing to remember is that an employee who is employed in a household is, by and large, an employee. And whether they are an employee in an office or a household still makes them an employee. And the employer, regardless of it being a household or a company, is subject to the same rules and regulations and obligations as an employer. So the same rules apply. And often my clients who are households think, oh, maybe it's a little more informal or there's some flexibility if it's a household. Unfortunately, not. It's the same rules that apply. And legally, every employee needs to have been given some written statement of their basic terms within 2 months of starting employment.
Okay.
So that often comes from an agency, or it can be just written down as the basic terms, but they always need that within 2 months of starting.
Okay. So I guess the next question that follows on from that is what should be included in the employment contract? What's important to have in there?
Mm-hmm. Well, from a statutory point of view, there are some key terms that are required to go in an employment contract. There'll be things like the name and details of the employer and the employee, their role, their duties to some extent, their place of work, their pay, their hours of work, holidays, pensions, um, whether or not they're part of a collective agreement. So these are the basic key terms that need to go into an employment contract, regardless of who the employee is. The thing with the difference that comes with my clients and domestic clients, so households, is that when you have a domestic worker in your household, they are different to an office worker in an office, insofar as they live in the household or they stay in the household. They know everything about that household. They know the inner working life of that household. They know who all the family members are. They know what they do. They know their preferences. They know where they go out. They know how they go out. Do they fly? Are they getting chauffeured? They know all their diary movements. They know who the family friends are, who the contacts are, what they're thinking, what they're talking about. So they have so much vital information about that household. And that requires a certain extra degree of protection for a client if they are looking for greater privacy and confidentiality in what is going on within their household in order to keep it within their household. Often households who have a lot of staff are high profile households, and those types of households, for whatever reason, attract attention in the media. And it's important to understand that every level of employee that works in the household as a domestic worker is seen as a gateway into the inner workings of that secret household, and can be used or encouraged by anybody from the outside world to dish the dirt or give some information on that household, which for some reason is attractive to the press and social media alike.
Mm.
So it is important, if you're looking to protect a household, that you're looking at an employment contract that has more than just the basic terms that go into a regular employee's contract.
So would this then be a separate non-disclosure agreement that you would have separate to that, or does the contract cover everything?
Right. So yeah, what um, we specialize in employment contracts for these types of clients. And so our employment contracts are more comprehensive than what is just statutorily required, because they covered the household situation. So they would have very comprehensive privacy and confidentiality clauses. They also have intellectual property clauses to ensure that the family own the rights of any photographs that are taken by any staff member at any time, so they can't be sold off and used by somebody else. They have more social media clauses in there. There'll be clauses to do with what they what their qualifications are. So if they're a nanny, they'll need to be Ofsted registered. If they are close protection, they'll need SIA licensing. Drivers, obviously, chauffeurs will require their driving licenses and additional policies as well. They'll require extra flexibility, and clauses such as a holiday clause in a normal contract would say something like the employee shall give notice to the employer and take X number of days holiday per year. In a household, it doesn't always work like that, because often the household wants the employee to take holidays at certain times. So these kind of expectations need to be set in the contract, not when they're going to take the holidays, but that the employer will require the employee to take holidays at certain times.
And I think that was a question that I was going to ask you, because from my previous life, when I was working as a private PA and a chief of staff, one of the grey areas for us was always the amount of flexibility that my clients wanted, and I suppose what we could get away with within a contract. So are you able to expand on that? How much of flexibility are you able to ask of a domestic staff member?
Well, for instance, in hours of work, you would put down the hours that you are expecting them to work. But you would also say that because it's a domestic situation, you require more flexibility. Now, ultimately, it's governed by the working time regulations. There are some exemptions that apply to domestic workers. But additional to that, I have clients who, for instance, say to me, well, I need the butler to work until midnight every day, and then I need them to start at 7 a.m. It's just the way we need it to be done. Well, these things are possible, and we would work with the client to see how we can achieve, insofar as is possible within the law, a happy medium. This sometimes will mean a supplementary agreement that the employees agree to for extra flexibility within the parameters of the law, but it has to be then a supplementary agreement. So you would need to liaise quite closely with the lawyer to ensure that those terms are put in place.
So would that be opting out of the Working Time Directive?
Well, the Working Time Directive doesn't necessarily have to apply, so you can already opt out of that and state in the contract that you're opting out. And there are also some exemptions that apply to domestic workers as well. But this is in addition to that. So, for instance, within the working time regulations, an employee will still need to have 11 hours of rest, a rest period block of 11 hours per night as their night time. That can be extended in a supplementary agreement such that their night time starts at a different time. They need to have a 20-minute rest after every 6 hours of a solid block of work. And they need to take off 1 day per week. They need to have off, or 2 days in every 14 days of work. So there are some legal guidelines, but there are also ways of stretching those legal guidelines, but only with cooperation of the household manager or the principal, because if you do have a supplementary agreement, it will usually require the individuals to take compensatory rest at a different time. So that also needs to be given. So although you can stretch a domestic worker slightly more if they are part of this other supplementary agreement, um, there are still rules that you would need to abide by and rest that would need to be given. So there's a bit of give and take, but it's a dialogue that would need to happen between the client and their lawyer to make it happen. And the importance in having compliance is that I know clients sometimes think, oh, well, it doesn't matter. We'll put this in the contract, but we'll do something different.
Yeah.
At the end of the day, if you put something in the contract, but you do something different, if a case is brought against you and you end up in a tribunal, the court will judge the situation based on what actually happens, not necessarily what happens on paper. So you will have effectively superseded whatever is written down. So it's important to work with the lawyer to actually try and understand the law, work within the parameters, because it's entirely possible. It's entirely possible to work within the parameters and then to have that written down, and that will give you guidance, or give the house manager guidance as to what they can do and how they can work the rotas, so everybody's legally compliant and the client gets what they need as well, and the requirements are met. So there's a legal solution to everything. It just needs the client needs to have that dialogue with their lawyer so that we can.
And one of the points that you raised, which is quite relevant at the moment with what's going on in the newspapers with Philip Green, actually, I think, about the whole non-disclosure and the level of visibility that our clients have in terms of what their staff can see. One of the areas that I think is just becoming a real concern, actually, for our clients and for our house managers and PAs is how to manage their staff and their use of social media. Particularly, I can give an example of one of our house managers having a member of their team taking an innocent photo of themselves at work, which showed that they were on the yacht. If you zoom in, you could see the yacht. You could see that straight away that the family weren't at their principal home because everyone was on holiday. So the security implications around that are huge. So is that something that comes up quite often within your contracts and with your clients?
Yes, definitely. We would have in our contracts under a section that's conduct during employment. We would have a set of rules that make it very clear what the employee can and can't do during their working hours. And taking photographs is quite a critical one, because now everybody has a camera on their phone, and so it's so easy to take that picture, and that's why it's important to have clauses that also give the right back to the principal to have those photographs, and also rights to have those photographs deleted if they find out, and rights to those photographs if they are published in any way, and also the right to tell the employee that they're not allowed to take it in the first place. So if you have it in the contract, so key to any employment relationship is that the employee needs to know what they can and can't do. And that's fundamental in a contract, that you should tell them what they can and can't do. And if you make it clear to them that actually taking photographs of the family home, the family friends, and in our contracts, we would define the family quite widely as well, and specifically, but widely, so that it's really clear to the employee who is being protected, and their contacts, their family, their friends, and their homes, because it's not only the home that they work in London, it could be their home, in different locations around the world, and it could be on the yacht. So all these would be defined terms in the contract, and it should be pretty clear to them that they wouldn't have been allowed to take that picture in the first place.
What do you do if you've got a live-in member of staff? So their home is effectively the client's home, and obviously they've got their days off when they should be allowed to relax. And can you still stipulate use of social media even then?
Well, use of social media could be restricted during working hours, but use of social media and taking pictures in the household should still be restricted because that's still, although it's their private place, it's also the principal's home. So maybe if there was a situation like that, it might be possible for them to take pictures within their room, but not within the wider common parts of the house or in the general property of the.
And all of this could be stipulated.
This could all be stipulated. And another thing to note is if you do have live-in staff, you need to ensure that you have a separate agreement that ties the employment contract to the rights of the individual to stay in the property. Because sometimes we have clients who will rent or provide a property to an employee which is outside of the family home, but it's still tied to their employment. And if you have an employee who's living in the property that belongs to the principal, but then you terminate the employment contract, you want to be able to have them vacate that flat or property that you've provided them with.
And is there legally, is there a notice period with that? Or again, can the client decide what that period would be? So if they were to terminate that person's contract, is there a separate legal law in place that means that you have to give someone a certain amount of notice or not?
To vacate?
Yeah, to vacate.
It's usually going to be reasonable. And in practice, what we usually do is give the same amount of notice as you do for the employment contract. So you would provide them with the same or sometimes more notice. It depends on how you're terminating and the relationship termination. I had a recent one where the employee wanted to stay in the flat for another 9 months after termination. And the principal was very generous and did allow that, but it did require additional wording in a settlement agreement to ensure that the individual wasn't obtaining more rights than she started with in terms of tenancy rights and occupation rights in the flat. So we needed some clever wording in the settlement agreement to ensure that wasn't the case. So the two usually are tied together, and you'd need separate agreements to make that happen.
I mean, I think one thing that I would advise anybody in a senior sort of hiring position within a private household is to know inside out. It surprises me that some people don't. And I know when I was hiring staff, I would sometimes sit down with them and we would literally read it together because the legal speak can be quite difficult to understand. I think it was really important to be transparent.
Absolutely.
Especially the areas that are kind of very bespoke to that particular client that's within the contract. So I think just in terms of a hiring process, to just ensure that you're hand-holding really that candidate through the process, because it can be quite intimidating.
Absolutely.
And you just need to feel that they're fully informed, I think, before they come on board and then they're locked in.
Yeah, absolutely. That's critical, because if the employee doesn't know what's expected of them, then how can you ask them to perform in that way? But yeah, often we get questions even after we've drafted the contract that the employee's not happy about certain elements, or could I explain the reason that we've got that clause or something else, because sometimes the intellectual property clauses can be quite legalistic. But yeah, there are simple ways of explaining it, and employees can be quite happy with it once they understand what it is. But sometimes we've even had to translate contracts into other languages because the staff aren't necessarily going to be speaking English to the level that's required for the contract.
If you've got, as many of our clients have, multiple estates, and you need your staff member to travel in between them, how do you negate against any worry around that within the contract? Is it just the principal residence that you put down, or do you have to list every single house? How does that work?
Well, in every contract, legally you need to say what the place of work is going to be. So you might say the principal place of work might be the London home, or you might say, well, actually, I'd probably say and any other place of work that is deemed reasonable, or that the employer will require you to travel to X, Y, and Z countries. And what you do need to say in the contract is if they are required to work outside of the UK for more than a month, then you need to give them specific information on what their terms and conditions might be if they're going to be any different. In practice, the terms and conditions usually stay the same. So an employee might take a butler to, say, Jamaica or Ibiza for 3 months in the summer holidays. That would be normal, and it would be stipulated in the contract that they may be required to work outside of the UK. And you would just let the employee know that the terms and conditions are going to be the same. They're still going to be paid via the payroll in London, and it's still the same terms. But then they may, I mean, it's never really happened that you need to even spell out the travel arrangements, because the travel arrangements are usually covered by the employer. So they're usually flown out to wherever. If they're not on the private jet, then they might be flown out separately, and then flown around the world at different times. But it's usually all covered by the employer. If it's not, then it should be stated.
And how often should families be updating their contracts? Because I think that's another issue that I've come across in my career, where they've had a contract that is 10 years old and they just sort of dish it out to every new member of staff. So with your clients, how often do you recommend them sort of reviewing their contracts?
Well, my clients are usually in touch with me regularly when they are hiring somebody new. And the reason for that is because different roles require different contracts. So a chauffeur's contract is going to be different to a governess's contract, because they're going to have different qualifications and expertise and different requirements. So it's important not to roll out the same contract just in case you miss something. Also, there are always changes that are being made, either legally, such as the GDPR, which came in May. So there will be GDPR requirements that need to go in there. Before that, there were pension issues that needed to be addressed in a contract. So there are always some tweaks that need to be made to a contract and the terms based on legal changes or case law. But in addition to that, with our contracts, what we do is, because we have a number of these type of specialist clients, is that we're always updating our contracts based on any new learning that has occurred just through trial and error and circumstances. And then some new matter comes along and you think, oh, that could have been done if we had put that in the contract in this way. It could have been addressed that way. And if things could be tweaked and made better, then we're always improving our contracts and making them tighter and even better, fit for purpose. So for that reason, it is useful to keep in touch with your lawyer, because, for instance, even a contract that I would have provided 5 or 7 years ago would now be updated, not only legally, but also with regards to clauses that have been added or streamlined in light of other experiences that my other clients have had.
So just one of the areas that we were talking about was social media. Another question that we had, which I think kind of links in, was about the use of CCTV cameras in the house. We had one of our candidates send in a question asking if she needs to let her staff know that there are CCTV cameras in all of the houses. At present, they don't know. The client likes to be able to check in on what the staff are doing. So is it a legal requirement now? I think
yes, it is. So since the introduction of the GDPR in May this year, in fact, it is a legal requirement that an employer is firstly registered with the Information Commissioner's Office. This is something that, yes, employers are not always aware of, especially in a household. If they're employing staff, and especially if they have CCTV and they're holding some data, they need to be registered with the ICO. The second thing that they need to do is they need to have a data, like a data protection policy. They need to have that for their own protection. And most importantly, they need to have a privacy notice. So alongside a contract of employment, we now draft privacy notices which each employee needs to be given. And a privacy notice Because under the GDPR, an employee is entitled to know what data the employer is holding about them and how they are processing the data, why they're processing it, whether it's going out of the UK, and they need to have access to that data. Now, if we go back to what I said before, the importance of running a household as, just in the same way as an employer as you would if you had an office, so the same rules apply. And data protection now is such a big issue,
Yeah.
and it's an equally live issue, if not more, in a household, but it is not commonly known. Though I've informed all my clients, not all clients are going
Yeah.
to be aware
Yeah.
that data protection is a big issue. So they still will need to tell their employees that they have what data they hold. Now, CCTV captures data. When the video footage is data, is information about that individual from which they are identifiable. So it's their personal data. And an employer most certainly needs to inform that employee that they're holding that data, who has access to that data, so what they're doing with that footage, how they're retaining the footage and for how long, and who's watching the footage. So for instance, gone are the days where somebody can just sit in, say, an open kitchen or an open place with a whole wall full of cameras so everybody can see.
Yeah.
That's not really in the spirit of the GDPR.